Welcome to the first video for the International Criminal Law course. Today I will begin by introducing you to the historical rise of international criminal law. We'll then take a look at a few of the cases from your reading that will further introduce you to the importance of international criminal law for both international and domestic criminal cases, and to the sources of international law that might affect any particular matter. Over the course of the next semester, I hope you'll enjoy learning about the international nature of American criminal law and criminal procedure, and about the body of criminal law created by the international community specifically to address some of the most egregious criminal violations in history and the special tribunals created to prosecute these matters. As you can see, there will be a number of PowerPoint slides as part of this presentation, and you should pause now to ensure that you have downloaded these PowerPoint slides from our D2L page to ensure that you can read them and see them legibly as I move through the materials today. So let us begin by looking at a few examples of international criminal law as we begin to consider what is international criminal law and what does it represent. The first example that I've put up here on the board is from the situation in the Democratic Republic of Congo, and it involves a rebel leader of the Union of Congolese Patriots. His name, Thomas Lobongo Dillo, and he was the first individual prosecuted by the Permanent International Criminal Court created in The Hague in the early 2000s. Congo became an independent state in 1960, and in 1994, a massive inflow of refugees from Rwanda and Burundi sparked unrest. A coup followed, and Laurent Kabila became president. In 1998, he was challenged by a second revolution supported by Rwanda and Uganda, and during that war, Lobongo was a commander of the pro-Ugandan army. In 2002, a peace treaty was signed, and by 2003, a transitional government was established. Despite the peace treaty, however, a second Congo war spun off from the original conflict, and it occurred in the Ituri region. The conflict was between agriculturalists and pastoralists, and the conflict raged from 1999 to 2007. During that time, Lobongo was a leader of a largely pastoralist rebel group and was alleged to have committed mass atrocities, including enlisting child soldiers, genocide, and war crimes. In February 2006, Lobongo became the first person ever arrested under a warrant issued by the International Criminal Court. His trial began in 2009. He was convicted in 2012 and sentenced to 14 years in prison. A matter that you may be familiar with is the conflict in the Sudan. The Darfur Civil War began in February 2003 and is an ethnic war in the west of Sudan. On one side of the conflict is the Sudanese military and a militia group. On the other, a rebel group recruited primarily from the Zaghawa and Masalt ethnic groups. The conflict has been described by many as genocide, particularly because of the number of civilians who have been killed. Upwards of 400,000 people have died, and over 2.5 million people have been displaced. In 2006, the United Nations approved a 26,000-person peacekeeping force, and in 2008, the International Criminal Court filed charges against Sudan's president, Omar al-Bashir. The charges alleged that he, quote, masterminded and implemented a plan to destroy in substantial part, end quote, 3 tribal groups in Darfur because of their ethnicity. President al-Bashir has refused to surrender to the ICC and remains in control of the country today. Before the creation of the ICC, as we'll learn later today, there were several ad hoc tribunals created to address various major conflicts around the world. One such ad hoc tribunal was created specifically to address the situation in Yugoslavia. The individual pictured here in the PowerPoint slide, Radovan Karadzic, is one of the key figures in the Yugoslav conflict and was prosecuted by the International Tribunal for the former Yugoslavia. The Yugoslavian War was a series of conflicts in the 6 republics of the former Yugoslavia from 1991 to 2001. The conflicts included ethnic conflicts between Serbs on the one side and Croats, Bosniaks, and Albanians on the other. The conflicts were the worst in Europe since World War II. They were also the first in Europe to be recognized as genocide since the end of World War II. As a result, many of those involved in this conflict were charged with war crimes. Some were charged in the former Yugoslavian republics using domestic or hybrid courts, but the most egregious of the defendants were taken to The Hague and prosecuted by an international tribunal called the ICTY. One such individual was Radovan Karadzic. He was captured in Belgrade on July the 21st, 2008, and extradited to the Netherlands. He was accused of initiating the siege of Sarajevo, ordering massacres, and establishing concentration camps. He is also alleged to have ordered that UN security forces be taken hostage in 1995. His trial began in 2009, and he was convicted in 2016 and sentenced to 40 years in prison. Another fairly recent conflict implicating international criminal law was the civil war in Libya. In particular, with regards to the civil war in Libya, Muammar Gaddafi's actions came under scrutiny by the international community, and the matter was referred to the International Criminal Court by the UN Security Council in 2011. An arrest warrant was then issued by the ICC for Muammar Gaddafi in June of 2011. He was charged with crimes against humanity related to the military response to the uprising that had begun in 2011. Before he could be captured and extradited to the International Criminal Court in The Hague, he was killed on October the 20th, 2011. A few additional examples from recent events. The conflict in Syria. The civil war in Syria broke out around the same time as Libya in 2011, and it is a conflict between the president, Bashir al-Assad, and rebel groups seeking his overthrow. The United Nations is currently investigating whether the regime in Syria has used chemical weapons in the conflict, which would be a violation of international law. This matter, however, has not been referred to the International Criminal Court in The Hague, and the reason in part is because Russia backs President Bashir and would veto a referral to the International Criminal Court by the UN Security Council. We'll learn more about the International Criminal Court later today and later this semester, and you'll begin to appreciate the functions of how cases come before the ICC and the important role of the United Nations Security Council in coming to those referral decisions. When we talk about international criminal law, of course, we're not just talking about those special international crimes that have been committed and created over time to address the most egregious offenders. International crimes such as war crimes, crimes against humanity, the crime of aggression, and genocide. When we talk about international criminal law, we're also talking about the application of U.S. domestic criminal law in the international theater. And so let's take a look at a couple of examples of those types of cases before we delve into the materials for today. One example of the application of U.S. domestic criminal law in the international criminal law theater is the investigation that the Department of Justice has been conducting over the last few years of Japanese auto part makers. The allegation from the Department of Justice is that these automakers have colluded together to engage in offenses such as price fixing, bid rigging, and other anti-competitive behavior that has all occurred in Japan and has all been orchestrated not by American citizens but by Japanese citizens in Japan. Nevertheless, the Department of Justice has alleged that this conduct has affected the United States because U.S. consumers have been hurt by the increased prices that have to be paid for these auto parts as a result of these conspiracies. And using that jurisdictional hook, the Department of Justice has applied these U.S. anti-competition laws to these Japanese automakers. And they've done so very successfully. 64 individuals and 44 companies have been charged thus far. Many have pled guilty, have been either extradited to the United States or have voluntarily flown to the United States and surrendered themselves. And the Department of Justice has collected more than $2.7 billion in fines using these U.S. statutes in the international arena. Another example of this use of U.S. laws internationally is in the area of narcotics. In 2013, Joseph Hunter, a former U.S. Army sniper, was arrested in Thailand and accused of running an international cartel of hitmen for the drug industries, the illegal drug industries, I should say. The DEA alleged that he had plotted to kill a DEA agent for $800,000. After he was arrested by Thai authorities, he was handed over to U.S. DEA agents who, as you can see in this picture at the bottom of the slide, quickly put him on an airplane, brought him back to the United States. He stood trial as having violated U.S. laws through his international behavior and was sentenced to 20 years in prison after being convicted in a New York federal courtroom. You may recall that in 2009, Mr. Muse hijacked the merchant ship Maersk, Alabama, and took its captain, Captain Phillips, hostage. There was a movie with Tom Hanks made about this event. Well, this was an act of piracy. And after U.S. Navy SEALs killed several of the pirates and rescued Captain Phillips, they arrested Mr. Muse, who had survived. Mr. Muse was not a U.S. citizen. He was Somali. He had not committed his offense in the United States. It had occurred off the shore of Somalia. Yet the U.S. flew him to the United States, charged him under U.S. law with piracy. He was convicted in a New York federal court and sentenced to 405 months in prison. Again, an example of the international nature and application of even U.S. domestic law. So as we begin to delve into these materials, we're going to very quickly see that materials and a course about international criminal law is not just about what's happening in The Hague. It's not just about war crimes and the types of atrocities that we read about occurring other places in the globe. International criminal law, as these examples illustrate, is also about the application of domestic U.S. criminal law and criminal procedure internationally against a host of defendants, including U.S. and foreign corporations. As an example, Hewlett-Packard was under investigation by the Department of Justice and the Securities and Exchange Commission for payment of a $10.9 million bribe to a Russian federal prosecutor's office in return for securing a very lucrative computer contract. This, the DOJ alleged, was a violation of a U.S. law, the Foreign Corrupt Practices Act. The bribe was given by non-U.S. citizens working for Hewlett-Packard in Germany. The recipients of the bribes were Russian nationals in Russia. The contract they were bidding for was a contract in Russia. And yet, U.S. law applied. And after an extensive investigation, Hewlett-Packard Russian unit pled guilty to violations of the U.S. Foreign Corrupt Practices Act in U.S. court and paid a $108 million fine. So again, there's a lot of material that we're going to cover this semester, and it's going to cover a lot of ground that you will inevitably encounter during your career if you move into the criminal law area. Even if you choose not to prosecute war criminals in The Hague, you are very likely, if you do have a criminal law practice in the United States, you are very likely to encounter international application of U.S. domestic laws. All right, so with those few examples as a backdrop, and as we begin to get a better picture of what is international criminal law and how does it apply, let's take a step back historically and talk a little bit about the historical development of international criminal law over time. There are four standard bases for the development of international criminal law historically. The theological and secular theory of just war, 19th century piracy prohibitions, along with the regulation and prohibition of slavery, and finally, the development of international humanitarian law, particularly in the early 20th century, around the time of the First and Second World Wars. So let's take a look at each of these in turn. And by looking at these four different areas and their development over time, we'll begin to get a better sense of how they came together to create a large body of international criminal law as it exists today. So if we look back to theological and secular theories, one term that we will see consistently used, and we will continue even today to see this term used, is jus ad bellum. Jus ad bellum, which essentially means just war. This is a set of rules regulating the use of military force in international relations. Going all the way back to the 12th century, St. Thomas Aquinas set forth three requirements for a just war. One, it must be authorized by a legitimate sovereign. Two, it must be necessary for the achievement of a just cause. And three, it must be for a right intention, such as the restoration of a good and just order. We continue to see these themes in today's international criminal law. And in particular, you're going to see these themes again when we talk about the development of international humanitarian law, that fourth prong in the development of international criminal law over time. By the 16th century, it had become acceptable that there may be just war, jus ad bellum, on both sides. And the focus then began to shift to another term that, again, you will see in much of your reading, a term that continues to be used today as we think about international relations and particularly international conflicts. And that is jus in bello. Jus in bello, which means the just effects of the war, rather than a just war itself. By the time of World War I, it had become generally accepted that it was the prerogative of the sovereign and a valid instrument of foreign policy to wage a war. So the focus on the idea of jus ad bellum, just war, began to diminish. And instead, we began to ask ourselves, when we engage in war, whatever the reason might be that the sovereigns decided to engage in conflict, how are we engaging in that war? Are we doing it in a just way? Are we doing it in a way that respects human rights and human dignity? The second prong for the historical rise of international criminal law is 19th century piracy, and I'll combine this with the third prong, the regulation of slavery, because both of these operated hand in hand as they began to expand the application of international criminal law in the mid to late 1800s. If we think about prohibitions on piracy and slavery, these are important foundational stones for the development of international criminal law for several reasons. One, they were the earliest international crimes recognized outside the context of war. So again, going back to the earlier theories of just war, the focus was on a conflict between states. In the 1800s, as the international community began to create crimes related not just to how you engaged in warfare, but crimes related to engaging in piracy and crimes related to engaging in the slave trade, this represented a significant shift away from merely believing that wars are properly regulated by the international community to believe that other conduct engaged in by individuals, could also be regulated by international criminal laws. Further, the prohibition on piracy, the regulation of slavery, indicated a shift in focus from nation states to individuals. Historically, the only ones who could be responsible for international crimes were not the soldiers on the field, but the states themselves. The regulation of slavery, the prohibitions on piracy, began a shift towards individual responsibility that we would eventually see trickle into the regulation of war itself, and the realization that we shouldn't just be holding states responsible for war crimes and the like, but we should also be holding individuals responsible for war crimes and other violations of international law. Finally, the prohibitions on piracy and regulation of slavery during the 1800s was also the basis for the modern notion of universal jurisdiction. We will talk more about jurisdiction later today when we look at the Lotus case, and we'll also spend one of our modules talking about different theories of establishing jurisdiction in international criminal prosecution. But for now, let me simply introduce what universal jurisdiction as one form of establishing jurisdiction means. The idea of universal jurisdiction, again, was developed in the context of piracy and the slave trade. It is something that has been expanded now to apply to a host of other crimes, and there's much debate about extending it also to terrorism offenses, although that has not yet happened. When universal jurisdiction applies to a particular international crime, it means that we need no jurisdictional hook whatsoever to prosecute an individual who is engaged in that conduct. Rather, whoever can get their hands on that person can try them for a crime that is committed anywhere in the world against any victim, by any perpetrator, affecting anyone. Obviously, piracy and the slave trade were the natural place to begin applying the notion of universal jurisdiction, because those engaging in this criminal conduct were often on the seas, in international waters, and often had no allegiance to any sovereign. Pirates, as an example, had no allegiance to a country. They operated on their own, and they operated in international waters if more than mere capture was required to establish jurisdiction. It would be essentially impossible to prosecute them anywhere. And so we created the idea of universal jurisdiction in the 1800s to apply to these crimes, so that we could continue to prosecute those who engaged in this misconduct. Again, that is the third area that piracy and the slave trade contributed to the development of international criminal law. The fourth prong to the development historically of international criminal law, as I mentioned, was the development of international humanitarian law. And really, this dates back several hundred years. But at the same time, we really began to see an expansion of the notion of international humanitarian law in the 1900s, around the time of World War I and World War II. And again, these notions in combination with the other prongs of the development of international criminal law, secular and theological theories, piracy, the slave trade, all came together in the 20th century to lead us to where we are today. So to focus for a moment on the development of international humanitarian law, we can go all the way back to 1139, when the international community recognized that certain weapons were cruel and inhumane. In that year, the Second Lateran Council condemned the use of the crossbow under Pope Innocent II. In modern time, we look to the Hague Conventions, dating back to the late 1800s, which limited the tactics of war and prohibited the use of certain weapons that caused excessive suffering. A picture from our slide here are trenches from World War I, where there was extensive use of chemical weapons, something that has been outlawed subsequently under the idea of the Hague Law and prohibitions on the type of ways we engage in warfare. Again, here we see the convergence of the secular and theological theories we examined earlier about just war and engaging in a just war with certain means. In modern time, we would also look to the Geneva Conventions of 1948 and 1949 and the 1977 protocols, which established the International Red Cross and protections for individuals impacted by war, including POWs and civilians. The earliest recorded trial of an individual for war crimes was the prosecution of William Wallace by an English court in 1305. Wallace was an English landowner, and you may know him as Braveheart from the Mel Gibson movie. He was charged with waging war against the English, quote, sparing neither age nor sex, monk nor nun. And as you may know, he was executed for those war crimes. In 1865, Henry Wirtz, a Confederate captain in the U.S. Civil War, was convicted of mistreating and murdering Union soldiers detained in Andersonville prison in violation of the laws and customs of war. So yet another example of the historical development of these notions of international crimes. As we move forward, we see the next big moment for the development of international criminal law occurring in the aftermath of World War I. It was at this time, after World War I had ended, that the world made its first global attempt to address international crimes through the exercise of both international and domestic jurisdiction. The allegations of German atrocities during the war were lengthy, and so as part of the 1919 Treaty of Versailles, an international tribunal was formed to prosecute Kaiser Wilhelm II, who was singled out for his role in orchestrating Germany's crimes during the conflict. Unfortunately, the Kaiser, however, fled to the Netherlands, which refused to extradite him, as that country had remained neutral during the conflict. The U.S. attempted to kidnap him, what we might call today a rendition, but was unsuccessful, and he later died in 1941. As we move through the semester, that historical example contains numerous topics that we will examine. Extradition, renditions, asserting jurisdiction over a head of state, asserting jurisdiction over an individual who has committed an international crime, perhaps in a different jurisdiction than the court is located. Again, the themes that have been present in the development of international criminal law continue to be topics for examination today as this relatively new area of law continues to develop. Despite the fact that the United States and others could not prosecute Kaiser Wilhelm II because he had escaped to the Netherlands, there was also an effort to prosecute others after World War I, but not before an international tribunal. Rather, Germany agreed that they would prosecute additional war criminals using domestic German courts. This became known as the Leipzig trials. They were generally, however, considered to be a travesty, as there were very few trials, and for those few who were tried, few convictions, and for those few who were convicted, excessively lenient punishments. Historically, the experiences with both Kaiser Wilhelm II and with the Leipzig trials served as an important moment in defining what would happen after World War II, perhaps the most significant moment in the development of international criminal law. The end of World War II is a watershed moment. It was then that two international tribunals were established to successfully prosecute violations of international criminal law for the first time. The tribunal charters allowed the prosecution of crimes against the peace, crimes against humanity, and war crimes. Although genocide had certainly occurred, the Genocide Convention was not to be passed for several years, and therefore that crime, as a crime that could be prosecuted, did not actually exist at the time of the Nuremberg trials. For the European theater, the Nuremberg trials were led by the Allied powers. 24 high-ranking Nazi leaders were indicted, 21 were tried, and 18 were convicted. This is what is known today as the trial of the major war criminals. The Tokyo Tribunal was led by General MacArthur and a single chief counsel selected by him. 26 individuals were convicted before the Tokyo Tribunal. The majority of prosecutions after the war were not conducted by this single international military tribunal. Rather, the vast majority of prosecutions for crimes committed during the war were conducted by the Allied powers individually in their zones of power, and these have become known as the zone trials after World War II. In total, more than 5,000 trials were held of German and Japanese prisoners of war accused of committing war crimes and crimes against humanity. Following World War II, there was a flurry of activity regarding international criminal law because many considered what had happened in the Nuremberg tribunals, in the zone trials, and in the similar trials in Japan to be a great success. After this, the United Nations was created, and the Charter stated that the use of force was prohibited with two exceptions: Security Council approval or measures taken in self-defense. In 1948, the Geneva Convention and 4 Geneva Conventions of 1949 established various protections for classes of people during war. And various other treaties were passed in the coming years, including treaties prohibiting torture, apartheid, and terrorism. As the Cold War intensified, however, progress began to stall, and it would remain that way for almost 40 years, as the two sides of the Cold War conflict failed to come together to continue to develop international criminal law in the way that it had been developing shortly after World War II. All of this began to change following the collapse of the Berlin Wall and the end of the Cold War in the early 1990s, but unfortunately, it developed in part because of atrocities occurring in both Yugoslavia and Rwanda. In the former country of Yugoslavia, which had dissolved after the death of the dictator Tito, there was a civil war. There was ethnic cleansing, and in response, the United Nations ordered the establishment of a commission to document the violations of international law. In Resolution 808, the United Nations Security Council established a special tribunal, what we call an ad hoc tribunal, for the prosecution of those responsible for serious violations of international humanitarian law during the Yugoslav conflict. This was called the International Criminal Tribunal for Yugoslavia, and it was formed in The Hague. The next year, Rwanda was engulfed in genocide. Upwards of 800,000 Tutsi and moderate Hutus were killed in just a 4-month period. UN Resolution 955 established the International Criminal Tribunal for Rwanda, what is known as the ICTR. The ICTY and the ICTR are organs of the United Nations and are called ad hoc tribunals because they are limited to a specific country, set of crimes, and a specific time period. The success of the Yugoslav and Rwandan tribunals led to proposals for the creation of a permanent international criminal court in The Hague. In 1998, the Rome Treaty was finalized, establishing the ICC. The ICC then entered into force in 2002 with the 60th country ratifying the treaty. Though, I will note, the United States has still not ratified that treaty. The ICC has jurisdiction over war crimes, the crime of aggression, crimes against humanity, and genocide. Though the U.S. initially signed the Rome Treaty, it was unsigned by President Bush upon taking office and never ratified by the U.S. Senate. At the moment, the U.S. does cooperate with the ICC, but it is not a member of the court. In addition to the International Criminal Court, which operates still today, there is a modern trend to also create what are called hybrid tribunals. These tribunals are created for particular events, but are not ad hoc because they are not formed exclusively by the United Nations, as the International Criminal Tribunal for the former Yugoslavia or the International Criminal Tribunal for Rwanda were. Rather, these hybrid tribunals are created by treaties between the United Nations and the country requesting assistance with prosecuting international crimes. As a result, they often contain both international judges and judges from the nation involved, and they also often use both international crimes and domestic criminal laws in prosecuting those brought before them for trial. As an example, in Cambodia, there was the creation of the Extraordinary Chamber in the courts of Cambodia to address the offenses committed by the Khmer Rouge. In this particular setting, the Cambodian judges are in the majority, and then there is a complement of international judges on the same panel. Similarly, Cambodian criminal procedure law is used along with some international law. So again, these hybrid tribunals are an example where we bring together some of the international nature of previous ad hoc tribunals and the International Criminal Court, and we combine them with local laws, local procedures, and local judges to create a hybrid international court. Another example of a hybrid tribunal is the Hague investigation of the assassination of former Prime Minister Rafi Hariri of Lebanon in February 2005. After his assassination, Lebanon asked in December 2005 for the United Nations to establish a tribunal of an international character to investigate the attack and try those found to be responsible. Lebanese law will be applied in the tribunal, except that there will be no capital punishment permitted. The maximum sentence will be life in prison. The judges will be international and Lebanese, with the majority of judges in this case being international, as compared with the Cambodian hybrid tribunal, where the majority of judges are Cambodian. The Lebanon tribunal is the first tribunal created to deal with terrorism as a distinct crime. And the UN has described terrorism as a, quote, threat to international peace and security. And that is one of the crimes that we'll be looking at this semester. Hybrid tribunals have become popular because it is thought that they address some of the concerns regarding the International Criminal Court in The Hague and the previous ad hoc tribunals for Yugoslavia and Rwanda. These include things such as legitimacy concerns. Some argue that international courts may lack a connection to the local population and therefore have a limited ability to seek credibility. Some also argue that with regards to the legitimacy issue, international criminal courts tend to only prosecute a very small number of defendants, and this may be corrected through use of a hybrid court. Another argument has to do with capacity building and the idea that a purely international court does not promote capacity building in the country in question, but a hybrid court where the investigations and prosecutions may occur in the country, where there may be interaction between judges of an international nature and local judges and others, that this might have the ability to assist in building the capacity of that country in the future to be able to prosecute these crimes domestically without assistance from the international community. And finally, and related to that, the idea of norm penetration, the idea that a purely international court may have little impact on the application and development of substantive norms criminalizing mass atrocities in transitional countries. Where there is a hybrid tribunal, on the other hand, perhaps there is a better work to create norms that will then steer that country in the future. Now, before we shift away from the history of the creation of international criminal laws and tribunals, and I'll look more specifically at the ways that U.S. laws apply internationally, let me spend just a few moments during this introduction to consider more closely the four main types of crimes created by the international community to deal with the most egregious of conduct. We will return to these four crimes more specifically towards the end of the semester, but I think it's helpful to consider them just a little bit more specifically now before we delve too deeply into the substantive materials for the semester. Again, those four crimes are war crimes, the crime of aggression, crimes against humanity, and genocide. These are the four crimes within the jurisdiction of the International Criminal Court. The first of these, the law of war, also known as war crimes. There are two main areas with regards to war crimes: Geneva law and Hague law. And I've already alluded to these two treaties and conventions, but let me explain a little more, in a little more detail, how each of these applies. When we talk about prosecuting someone for a war crime, we may be talking about prosecuting someone for a violation of Geneva law, or the Geneva Conventions. Those Geneva Conventions and subsequent protocols protect people impacted by war, and it applies where there is an armed conflict, whether between two states or between organized armed groups. There are four categories of protected persons under Geneva law: wounded and sick in the field, wounded and sick at sea, prisoners of war, and civilians. And each of these four groups receive protections under Geneva law. And the violation of those protections is considered a war crime. The protections include protecting civilians from being subjected to violence and killings, and protecting cultural and religious structures from deliberate targeting. Willfully killing a civilian during an armed conflict, for instance, is considered to be a, quote, grave breach of the Geneva Convention, because it is the responsibility of the state to protect civilians from war as much as possible. Geneva law also protects soldiers by giving prisoners of war certain rights and protections, including protections from execution for lawful acts on the battlefield. Now, as we know, civilians do die tragically during times of war. It's important to note that when we talk about Geneva law and when we talk about war crimes, we're talking about intentional killings of civilians. When we think about civilians who aren't targeted intentionally, but rather are casualties of war, we are not necessarily talking about a war crime. But to protect civilians as much as possible, we also have the idea of Hague law. And again, Hague law limits the use of force to military objectives, which means a military may not target a civilian target. That would be considered a war crime. They must target only a military objective. But what if that military objective is in the center of a town that contains 100,000 civilians? Again, we'll look at this more closely later in the semester, but it's worth mentioning now that Hague law requires we utilize a three-part test to determine whether our use of military force is lawful. Again, just because civilians die does not mean a war crime has occurred. The question is, related to that killing, was there a violation of Geneva law? Was there a violation of Hague law? If yes, then we have a war crime. So what are the three tests that we must utilize under Hague law when targeting a military objective? First, necessity. Armed attacks must be designed and intended to defeat the opponent militarily. Second, distinction. This requires that parties to an armed conflict distinguish between legitimate military targets and illegitimate targets such as civilians. It prohibits certain types of weapons that by their very nature do not discriminate against lawful versus unlawful targets. And third, proportionality. When military force is used for a proper military objective, only a level of force that is proportional to the military objective to be gained may be used. Civilian casualties in and of themselves are not necessarily unlawful, but you must have adhered to these three rules. The second international crime that I wanted to introduce you to is the crime of aggression. This was charged for the very first time at the Nuremberg trials. Under the Nuremberg statute, it said crimes against the peace, namely planning, preparation, initiation, or waging of a war of aggression, or a war in violation of international treaties, agreements, or assurances, or participation in a common plan or conspiracy for the accomplishment of any of the foregoing is a crime. Many argued that this was an example of victor's justice, the idea that the crime of aggression is something that is only imposed on the losing side. Over time, however, this crime has taken root and is now one of the established international crimes and is one of the crimes for which the International Criminal Court has jurisdiction. It is based today on the notion that the United Nations allows the use of force in very limited situations. The two most dominant, as I mentioned earlier, are Security Council authorization and when one is acting in self-defense. The final two crimes, crimes against humanity and genocide, are what are known as atrocity crimes. First, the crime against humanity. The definition is, quote, a constellation of acts made criminal under international law when they are committed within the context of a widespread and systematic attack against a civilian population with knowledge of that attack. Its formal origins date to World War I, though it was formally charged during Nuremberg. Although genocide was formally codified in treaty form, crimes against humanity were never mentioned in treaty, but were contained in both the charters of the ICTY and the ICTR. The final crime is genocide. Genocide is defined as the commission of one of a set of enumerated acts against members of a protected group with the intent to destroy the group in whole or in part. The goal of genocide is thus to eradicate a specific segment of humanity defined by race, ethnicity, religion, or nationality. Although an ancient scourge, the concept of genocide as a distinct international crime arose out of the Nazi Holocaust and World War II. The treaty codified the crime. The treaty codifying the crime came too late, however, and the Nazis were not charged with this offense. Rather, they were charged with crimes against humanity. But of course, genocide has been tried, unfortunately, since World War II, as there have been other examples where this crime has been committed. Now, with regards to these atrocity crimes, there are significant differences between crimes against humanity and genocide. One, only acts committed against groups identified by a common race, ethnicity, religion, or nationality may qualify as genocide. Criminal acts committed against any civilian population, not necessarily defined by any common group identity, can qualify as crimes against humanity, however. Second, genocide requires that the perpetrator have the specific intent to destroy a group because its members share a common racial, ethnic, religious, or national identity, whereas crimes against humanity do not require any form of specific intent. Third, crimes rise to the level of crimes against humanity when they are committed within the context of a, quote, widespread or systematic attack, end quote, against a civilian population. There is no similar threshold qualification for genocide. Therefore, a single isolated act may be genocide if the perpetrator acted with the requisite specific intent, whereas a single isolated act against a civilian is unlikely to qualify as a crime against humanity on its own. In the preceding materials, we considered the historical rise of international crimes, like war crimes and crimes against humanity, and the types of tribunals and courts that have been used over time to bring those responsible for these atrocities to justice. Again, this is just an introduction to this area, to give you a sense for the overview of the materials. We'll return to talk more specifically about these 4 international crimes and the various tribunals that have been used over time to prosecute those who have engaged in these acts later in the semester. Let's now turn, therefore, during this introductory session to a different topic regarding international law. And that is the manner in which U.S. domestic law and U.S. domestic criminal procedure can have important international components and reach as well. During this course, we will be examining various U.S. laws that apply not only to conduct undertaken in the United States, but which also involve conduct overseas and or defendants located overseas. There are many U.S. crimes that have an international focus and an international application, and I've listed here on the board a few examples of those. For example, the Foreign Corrupt Practices Act. We saw the application of this crime in the international context in our introduction with regard to Hewlett-Packard. Antitrust and securities regulations. we saw the application of those U.S. laws with regards to the Japanese auto part manufacturers. Export controls, computer crimes, narcotics, and money laundering. Narcotics, of course, we saw an example of with regards to the former U.S. Army sniper arrested for engaging in drug trafficking and murder in Thailand, extradited back to the United States to stand trial, convicted, sentenced in a U.S. court. Piracy and terrorism. We looked at the Somali pirate case with regards to Captain Phillips, and we saw how that Somali national engaged in the crime of piracy in Somali waters or international waters could still be a crime under U.S. law, and he was brought to the United States to stand trial for that international crime, applying U.S. statutes. Torture and human trafficking. We're going to take a look at a number of these crimes this semester as we work through the materials and consider the ways that U.S. laws can be important tools in international prosecutions. Similarly, this semester, we will ask ourselves about U.S. criminal procedure. U.S. criminal procedure is vital when considering international criminal law, particularly the application of U.S. crimes, such as those above, to U.S. citizens, or even to non-U.S. citizens. Remember, when we think about the crimes that we've listed here on the board that we're going to look at this semester, they can apply in a number of different ways. First, they may apply to conduct by a U.S. citizen abroad. Maybe an individual who is a U.S. citizen who's in the United States gets on a computer and commits a fraud in Europe. But that could still be a crime under U.S. law, even though the crime occurred somewhere else. Or maybe a U.S. citizen travels to Europe to commit a crime. But that may still be a crime under U.S. law, even though that crime occurred in a different country. Second, these crimes may apply to conduct by someone located outside the U.S. and not even a U.S. citizen if the conduct somehow impacts the United States. If a German national bribes a Russian national and the bribe travels by wire through a U.S. bank account, U.S. law now applies to that international crime. And third, where the conduct prohibited by U.S. domestic law is also a violation of the types of international laws and norms that we've looked at earlier in these materials. It may be the case that U.S. law can bring someone to the U.S. to stand trial for violating that U.S. statute regardless of where the offense occurred, or who committed the offense, or whether any U.S. interests or citizens were even affected. That would be the case if universal jurisdiction applied, such as is permitted to apply in piracy cases. And we discussed that idea of universal jurisdiction and the idea that that applies to certain crimes where we can prosecute someone as long as we can get our hands on them. There's no other jurisdictional hook required. But when we do have one of these criminal statutes implicated, where we do believe we have a potential violation of U.S. law in this international context, we have to also remember U.S. criminal procedure and the U.S. Constitution may be implicated. For example, does the U.S. Constitution apply where the Department of Justice conducts an investigation in a foreign country? In the Hewlett-Packard case, we learned about the investigation that was being conducted. In that setting, was there a constraint on the Department of Justice? Did they have to abide by the Fourth and Fifth Amendments when they were gathering evidence in Russia? What if Russian authorities gathered the evidence in violation of U.S. norms and then provided those materials to the United States? Could we still use them at trial? We'll consider these and related issues later this semester. Similarly, how do U.S. investigators collaborate with foreign enforcement agencies to gather evidence together? We'll talk about letters rogatory, we'll talk about mutual legal assistance treaties, and other mechanisms by which U.S. law enforcement can combine forces with foreign law enforcement to investigate international criminal behavior. And once a suspect is identified overseas, whether a U.S. citizen or not, how do we get them to the United States to stand trial? Some options include extradition, deportation, abduction, also called rendition. We attempted that with Kaiser Wilhelm II unsuccessfully. We have used rendition, as you saw from one of your cases today, to bring people to the United States to stand trial. There's also prisoner transfer. We'll consider each of these later this semester as well as we think about the application of U.S. constitutional law and U.S. criminal procedure in the international context. So this brief introduction to international criminal law covered a lot of ground. But I hope it's been a good overview of what we're going to be doing this semester and the types of applications of criminal law in the international context that you should be contemplating as we move through the materials. Perhaps this is broader than you perceived. Perhaps this is exactly what you thought it would be. But I hope that you've learned from today's materials that when we talk about international criminal law, we're talking about a lot more than just a handful of war crime trials at the International Criminal Court in The Hague. We're talking about an entire world of potential international criminal law applications that implicate both international law and domestic law. International courts and domestic courts. In the previous materials, we considered the rise of international criminal law over the centuries and the development of the four primary international crimes: war crimes, crimes against the peace, crimes against humanity, and genocide. We also considered the different types of tribunals and courts that were developed historically to bring those who violated these four international crimes to justice, such as the Nuremberg trials, the ad hoc tribunals for Yugoslavia and Rwanda, and finally the International Criminal Court in The Hague. We then considered U.S. domestic law, including bribery statutes, anti-competition statutes, narcotic statutes, and considered the ways U.S. law can be international itself. First, we recognize that U.S. law can prohibit conduct by U.S. citizens, even if the behavior occurs outside the United States. Second, we recognize that U.S. law can prohibit conduct even when it occurs outside our borders and is by a non-U.S. citizen. Usually these statutes require some minor connection to the United States, such as a fraud impacting the price of U.S. goods, or a wire transfer traveling through a U.S. bank account, but this is not always the case. As we noted with piracy, domestic criminal statutes based on the notion of universal jurisdiction do not need to require any such connection. And finally, we considered the ways the U.S. criminal procedure, including constitutional restrictions, might impact international investigations and prosecutions. We will return to all of these concepts in greater detail during the semester. This video lecture was merely intended to give you a broad overview of international criminal law and begin to introduce some of the topics and issues we will delve into more deeply this semester. So let me now focus more specifically on some of the materials from your reading this week with regards to the module Sources of International Law. As noted in your text, international criminal law is an amalgam of rules and principles drawn from both national and international law. In national legal systems, legal rules and principles are identified and validated by reference to formal sources of law, such as constitutions, statutes, case law, and regulations. While we may all be familiar with traditional sources of law in the United States, it's important as we begin this course to learn a little about sources of international law. This will help us better understand the materials we will encounter later in the semester, especially where we see judges contemplating the impact of international criminal law on a particular decision, including a U.S. court decision. Our starting place in understanding the sources of international criminal law is the restatement. In the restatement third of the Foreign Relations Law of the United States, Section 102 on sources of international law describes it as follows. A rule of international law is one that has been accepted as such by the international community of states, A, in the form of customary law, B, in international agreement, or C, by derivation from general principles common to the major legal systems of the world. The restatement then goes on to clarify each of these three sources of international law. And as we move through our cases this semester and we see courts discussing international law, we'll see each of these sources used. First, customary international law results from a general and consistent practice of states, followed by them from a sense of legal obligation, an international norm. This is accepted by almost everyone in the world as being the law, customary international law. Second, international agreements create law for the states parties thereto and may lead to the creation of customary international law when such agreements are intended for adherence by states generally and are in fact widely accepted. So as an example, almost every country in the world has signed the prohibition on the use of chemical weapons. So many countries, in fact, that it now applies under the idea of customary international law to everyone, regardless of whether you signed it or not. There you see two different types of sources of law. One, international agreement, and two, customary international law working together. Originally, when only a handful of countries had signed the prohibition on the use of chemical weapons, it was not an international norm. But those countries that had signed those agreements were bound by that law. But today, given that almost everyone has signed that document, it is now customary international law, and regardless of whether you signed that document or not, it is illegal to use chemical weapons. And third, general principles common to major legal systems, even if not incorporated or reflected in customary international law or international agreement, may be invoked as supplementary rules of international law where appropriate. This one's a little trickier, not quite as well defined, but it opens the door as courts begin to consider the influence of international law in any particular case, to the idea that even if we can't find a treaty or similar agreement on this topic, even if it has not become so widely adopted that is considered customary international law, maybe we can still look to it to guide our decision because it represents a general principle common to major legal systems in the world. One area where you'll see much discussion of this idea is with regards to capital punishment. Almost all legal systems in the world do not permit capital punishment, but the United States does. How does that influence a decision that implicates capital punishment and has an international legal aspect to it? Again, we're going to see this throughout the semester, and we see it in our first case from the book. The case of the SS Lotus involving a dispute before the predecessor to the current Permanent International Court of Justice. Jurisdictional issues have always been central to international criminal law, and this is exactly what is present in the Lotus case. This landmark case, probably the most significant decision of an international court on international criminal law, shows how international criminal issues can arise. The case involved a collision between a French ship and a Turkish ship, resulting in the death of 8 Turkish nationals. Turkish authorities questioned Mr. Demons, the first officer of the Lotus, a French ship, who was a French national, and proceeded to arrest him and Mr. Hassan Bey, the captain of the Baz Kurt, the Turkish ship. Notice was then not given to the French consul general in Turkey. Mr. Demons, the officer of the watch on the Lotus and at the relevant time, objected to the court's jurisdiction in Turkey. This objection was overruled, and he and Mr. Bey were both convicted of manslaughter. The French government then protested the action of the Turkish authorities, arguing that only the state under whose flag a vessel sails has jurisdiction to prosecute for actions that occurred on that vessel, such as being negligent, and that negligence leading to the death of another, manslaughter. Both France and Turkey were parties to the Convention of Lausanne of July 24, 1923, which was part of the World War I peace settlement, in which the old capitulations regime in Turkey was abolished. The convention provided that questions of jurisdiction between the parties were to be decided, quote, in accordance with the principles of international law. The French and Turkish governments submitted the question whether Turkey had acted in conflict with principles of international law in prosecuting Mr. Demons, along with a question regarding reparations. And they submitted these questions to the Permanent Court of International Justice, which was the predecessor of the current International Court of Justice that hears conflicts between states in The Hague. The court had to answer a number of questions, including how do we interpret this treaty? What role did the law of flag play, which is the law of the country of the flag under which the ship sailed? Was Turkey permitted to prosecute this case? And if yes, was this Turkish action trumped by international law restrictions or prohibitions? The court was evenly divided, and the president cast the deciding vote in favor of Turkey. Turkey had argued that it could use the principle of passive personality to establish jurisdiction in this case, which is the idea that a country has jurisdiction over a defendant if the victim of the crime was a national of that country. As a Turkish citizen was killed, Turkey asserted that it could therefore prosecute this matter. Alternatively, Turkey argued that it could use the principle of territoriality to establish jurisdiction, which is the idea that a country has jurisdiction over a defendant whose actions occur within its territory. Here, because the Turkish ship flew under the country's flag, it was considered part of Turkey. And so when the collision occurred, that collision happened within the territory of the country. Again, we're going to look at the different ways to establish jurisdiction, more specifically in a later class. For this case, the arguments regarding jurisdiction are important as you begin to examine the way that the court looked to various sources of international law to help guide its decision-making. In ruling for Turkey, the court rejected France's alternative argument that Turkey was only permitted to assert jurisdiction if international law specifically permitted jurisdiction in this case. The court instead agreed with Turkey that the country was free to assert jurisdiction in this matter as long as it was not specifically prohibited by international law. Two very different ways to cast that question, resulting in two very different outcomes. While the Lotus holding has been replaced by several treaties, the case remains important because it is a strong illustration of the importance of considering sources of international law in any particular dispute, and whether such law must permit the behavior or simply not prohibit it, something that remains debated today. The Lotus case is called the classic view. States are free to act internationally except in the face of a clear rule of prohibition. But as I mentioned, This has been much debated and overruled by various treaties. What is called the modern view argues for a less categorical approach, requiring consideration of a number of factors to determine whether jurisdiction is correct. Again, we'll look at jurisdiction again in the various ways that we might be able to establish jurisdiction in a later class. For purposes of this class, the Lotus case serves as a nice example of the importance of international criminal law and understanding the sources of international criminal law when these issues are implicated in a prosecution. As we look to our next case, the case of Felartiga v. Peña-Irala from the U.S. Court of Appeals for the Second Circuit, we see an example of customary international law being used to decide a matter not before an international court in The Hague, but rather before a U.S. domestic court. As we think about sources of international law, we must remember that this is not just applicable to war crimes prosecutions in The Hague or disputes between countries in The Hague. It's also very applicable in individual cases affecting individual people in U.S. courtrooms. In this case, the Second Circuit Court of Appeals used customary international law, one of the three types and sources of international law from the restatement, to resolve a case that arose under the U.S. Alien Tort Statute. In ruling that the plaintiffs could assert their torture claim in the United States, despite the events having occurred in Paraguay at the hands of a Paraguayan citizen, the court relied significantly on international law and its prohibitions on torture. In particular, the court considered the host of UN General Assembly resolutions prohibiting torture, along with various multinational treaties doing the same. The final paragraph of the case is a powerful reminder of the significance of international criminal law, both internationally and domestically. The court said, quote, "In the 20th century, the international community has come to recognize the common danger posed by the flagrant disregard of basic human rights, and particularly the right to be free of torture. Spurred by the Great War and then the Second, civilized nations have banded together to prescribe acceptable norms of international behavior. From the ashes of the Second World War arose the United Nations Organization, amid hopes that an era of peace and cooperation had at last begun. Though many of these aspirations have remained elusive goals, that circumstance cannot diminish the true progress that has been made. In the modern age, humanitarian and practical considerations have combined to lead the nations of the world to recognize that respect for fundamental human rights is in their individual and collective interest. Among the rights universally proclaimed by all nations, as we have noted, is the right to be free of physical torture. Indeed, for purposes of civil liability, the torturer has become, like the pirate and the slave trader before him, hostis humani geresis, an enemy of all mankind. Our holding today gives effect to a jurisdictional provision enacted by our first Congress, and it is a small but important step in the fulfillment of the ageless dream to free all people from brutal violence. In this quotation, we see not only reference to the importance of international criminal law in deciding certain U.S. cases, but also reference to some of the notions we have already examined today, including universal jurisdiction, piracy, slavery, and the aspirations that came after World War I and World War II. In our next case, Sosa v. Alvarez-Machen, a U.S. Supreme Court case from 2004, we see a similar issue. Here, again, we see the court focusing on international law in reaching its decision. In this case, Sosa, acting for the DEA and other Mexicans, kidnapped Alvarez from his house in Mexico and held him overnight in a motel before bringing him by private plane to Texas, where he was arrested by federal law enforcement officers. So the individual kidnappers are Mexican. The kidnapping occurs in Mexico. And then the individual is flown to the United States, where he is then handed over to U.S. authorities. In reaching his decision that Alvarez could not assert a claim against the United States under the Federal Tort Claims Act or the Alien Tort Statute, the court stated, quote, "It is enough to hold that a single illegal detention of less than a day, followed by the transfer of custody to lawful authorities and a prompt arraignment, violates no norm of customary international law, so well defined as to support the creation of a federal remedy." What the court is saying there is, we don't see any issue under U.S. law or under the U.S. Constitution. And when we look to international law to ask ourselves, does this violate customary international law? Does this violate a treaty? Does this action violate international norms? The court says no, it does not. And in so holding, they have used international criminal law to assist them in reaching their decision. In our final case for the day, Coble v. Royal Dutch Petroleum, we once again see strong reference to international criminal law as the court discusses the presumption against extraterritorial application of the statute in question. Each of these cases from today is an important introduction to international criminal law, as we consider not only the source of international law that might be significant to the decision and laws, we also look to consider how wide an impact international criminal law can have on the criminal justice system. As you can now see, international criminal law is not just an area of law that impacts war criminals in The Hague, but is also an area of law that can have significant ramifications for all different types of prosecutions and cases in the United States. We'll continue to develop our understanding of all of these ideas as we move through the semester, both the application of international law to U.S. statutes, to U.S. criminal procedure, and the 4 international crimes and the tribunals that have been created to prosecute them. Again, all of this will be our focus this semester. So thank you for joining me for our first video lecture, and I look forward to seeing you for our next module.